Right, we're back with liability for defective products. The first case I talked about was the Donahue-Stevenson case. The next one follows only 3 years later, Grant versus Australian Knitting Mills. The case is a little interesting in the fact that it was decided in the Privy Council. It was actually a case heard in Australia. The relevance of this case is it's really looking at the liabilities in regards to product defect, but also it's examining the question of intermediate examination, which did come up in Donahue and Stevenson. The facts of the case are that someone had worn some long johns, and they'd been impregnated with some sulphur, which subsequently caused illness, dermatitis, which apparently is quite serious. So again, we're going back to the old issues of contract versus tort. There was no contract, obviously, with the consumer because, with regard to the manufacturer, because the manufacturer had sold the goods to a retailer. One of the points made is that if an injury is sustained, even if it's intentional, as long as somebody actually was exercising a legal right, there's no recourse, legal recourse. The case was decided in favour of the consumer. Question of causation is really linked into intermediate examination, not duty. So that's an important distinction, and that is really coming from Griffiths versus Arch Engineering, 1968. Some just notes following this. In the modern day, under English law, Consumer Protection Act of 87 does provide for strict liability, so there's no need to prove actual carelessness on the part of the manufacturer. It's simply that the products were defective. It doesn't really matter how they were defective. In the same way, breach of warranty under contract, you merely have to prove that the products were defective. It's strict liability. Some further notes: Winterbottom versus Wright, which was a sort of, well, it was an 1842 case, and it was actually considered in the light of in the judgment in the Donahue and Stevenson case. Winterbottom, get this right now. Winterbottom versus Wright was actually a contractual matter, not in tort. Got a book reference, Historical Foundations of Common Law, and just quickly, there's a couple more case citations. Evans versus Tripex Safety Glass. Okay, this relates to causation that a windscreen had actually shattered, but there was no, even if the defendant had taken reasonable care, there's no actual, there was no proof that the defendant's action had actually caused the damage to occur. Just finally, a few comments about remoteness and foreseeability. So really the point of this case was to show that there was a latent defect in the long johns due to sulphur being in there. There was no reasonable possibility of examination by the consumer, and remoteness was satisfied. The manufacturers advanced an argument saying that if a ship's rudder were negligently made, then all the subsequent harm deriving from that, in terms of the ship actually crashing or being shipwrecked, then would actually be applied. The damages would then flow from the rudder's manufacturer. Well, obviously they wouldn't, because remoteness wouldn't be satisfied and there would be a number of other factors involved. So that was point satisfied, and hence the Grant versus Australian Knitting Mills case was actually awarded to the damages were actually awarded to the claimant, the consumer.